Open the public hearing on the fire safety inspections of commercial buildings. I'll ask Chief Hicks to give an overview, and then we'll turn to the public comments.
Good evening, Mayor and Council. Tonight I'm going to go over the proposed changes that staff is recommending that came from input that was given to us by the stakeholders at the January 12th council meeting. Also, you guys have a red line version at each one of your at the diocese, and I believe there's some out there. This version will also be on the website tomorrow for review. I'm going to go over, there's about 11 changes that staff is currently recommending. Change number 1 would be, after meeting with Focus, they're recommending that the word commercial is inserted into the ordinance name, and we have done so. Number 2, all city-owned buildings will be subject to inspections. Currently, when we originally started this, we just proposed that the ones for human habitation being proposed and included. Currently, what we're doing is now all buildings, so all means all. Storage buildings and everything that the city owns will be inspected, and we have currently started that process. We have about 6 of them done at this time. If a suggestion of Focus, the definition of what constitutes a governmental building has been broadened to temporarily include temporary structures. A definition has been provided for the term owner to clearly delineate that either the owner or the owner's legal representative identified in the building registration and who has the authority to act on behalf of the owner was inserted. One that's new and was not publicized and is in your guys' red line version up there is section C, subsection 1. This is a benefit to the property owner. We did not believe it was fair after reading through the ordinance that if you had any violations, you would be subject to re-inspect every year. So what we did is if you do pass your inspection, at the time of the re-inspection, you're not going to re-inspect it until the end of the 3rd-year period. The 6th one, at the request of Focus, the term inspection has been added to the definition of pre-planned walkthrough. Number 7, the definition of third-party inspections has been clarified to indicate that such inspections are not completed by the city or its agents, but rather by third parties. Number 8, both the fire safety inspection report and the pre-planned walkthrough report are documents, and they would be included in the ordinance and approved by council if you decide you want to change them. So there will be no changes unless you guys approve those changes firsthand. The 9th one is Focus had sought clarification of the applicability of the inspection process to include common areas of buildings and of residential uses, and we did a minor reversion of that language, and that has been provided to clarify the use. The 10th one, on the issue of building permit fee reductions, that section has been amended to reflect that the incentive is only available to remediate violations discovered in the first round of inspections. And number 11, on the issue of grandfathering, language was added to the ordinance that now requires the city to conduct a conference with the owner to identify the applicable codes based upon the age of the structure, the identification of the standard that is attained, and the identification of the standard which adequately protects the public safety. So there's a clear delineation on when the grandfathering clause would take effect. Those are the changes that we proposed. There is no other changes in the scope. It will still be done by on-duty firefighters with no additional staffing costs. I'll answer any questions you have. Otherwise, we can turn it over to you for your...
Okay. At this point, I'd like to turn to the public comments portion of the public hearing. We will be coming back to this in ordinance consideration under item G2.
Good evening, Linda Walt, 400 Leonard Avenue in DeKalb, Illinois. I'm here thanks to the council, the mayor, and members of the city administration for giving us an opportunity to talk about the ordinance. I've been here before, so I think that the staff is making an effort to deal with the stakeholders on this, and so I talk less and less because more and more things seem to be getting worked out, and we appreciate that. I'm still concerned about the fact that there's no Exhibit A attached to the ordinance, and I understand that's actually the report itself, the fire inspection report, and if I'm reading this correctly, You say in the ordinance that it's not going to be codified. I'm thinking that's why we're not getting a copy of Exhibit A. I continue to have issues with that issue because my sort of approach to this from the very beginning is people that have buildings need to know exactly what they have to do to pass the inspection. And so they need the notice that comes from having a copy of the report or the standard or whatever you're using to decide who is in compliance and who's not in compliance. So I remain committed to the idea that that needs to be done. The other thing is grandfathering. Members of the council know, and a few of the staff members know, I did write a letter, which you all should have received. I wrote what I consider to be a fairly good grandfathering provision. The city has not adopted that, and I'm not here to say that they have to, but I think that there are merits to the way that I wrote it, in that it's more specific language. It's not in the past tense. It actually says what the city does, instead of using "it shall happen," or it's not an "it," it's a city. And the city has power over us as property owners. And so if this is going to work at all, we have to get a handle on the grandfathering part of it, because if you would take a drive from Peace Road all the way through town on Lincoln Highway, let's just say you go to Annie Glidden Road, and you look at how many buildings you're going to inspect just from that ride. Because you're not talking about one building that faces Lincoln Highway. You may be talking about another building behind it, and another building behind it, and another building behind it. And these are people who are now going to be subject to the inspection, and everyone that knows anything knows that our stock of commercial buildings and industrial buildings in DeKalb is not the newest stock that you can find. We are lucky to have some newer buildings, but the rest of us are dealing with old buildings. So I just want to know, when you come in, what code's going to apply to me, how we're going to figure that out. You have a building that may have had 3 additions to the building. How is all of that going to be worked out? More specific language about affirming the fact that we have to deal with the issue that is going to be staring you in the face. Truly, I think within 24 hours of the day you start the inspections, you're going to have to be doing this. And so it's going to be work not only for the city, but also for the owners of the buildings. The only other thing I wanted to talk about is that maybe it's a little premature to have the first reading and to be making decisions yet. I think that there are a few more tweaks that could happen to the ordinance. But as I said, I do appreciate the efforts of the staff. I think that they've been cooperative and in talking with the stakeholders, and I think that we've made some progress, but maybe just not there yet. So thank you very much.
Linda. William Heinisch.
Good evening, Council. My name's Will Heinisch, local businessman, Focus representative, and a property owner. At 1 p.m. today, Mike Coughlin, who you're familiar with, has spoke before, but past state's attorney and a local lawyer, and I were able to sit down with Eric Hicks, the fire chief, Ellen DeVita, the community development coordinator, and Dean Frieders, the city attorney, to discuss the actual words of the ordinance and how it affects the concept of the ordinance. It actually is something I've requested several times, where you can have an engaging conversation back and forth instead of just coming up here and telling 3 minutes and spewing out words that, to my famous TV land people that like me, this engaging back and forth, which actual city staff, I think we learned a lot. And I think all 3 of them, when you actually engage back and forth and share that communication, it's what, because you can redline an ordinance and the city attorney can look at it, he can look at our red line, we can look at his red line, but until you actually get the backup material and understand the real red line, there's a lot of misconceptions and mischaracterizations that can happen. So I'd like to thank the city manager, though, for setting up that meeting we had today. We were only able to get through half of the ordinance. We met from roughly 1 to 2 o'clock, and we were able to make, I felt, a lot of progress in suggesting changes to the city ordinance in an attempt to clarify wording so both the city and the citizens are protected. Changes and clarifications in words such as complete inspections and all areas of the building to inspected, words such as any, which are very specific, and yet in the beginning of the ordinance, it talks about the ordinance being least intrusive. These words make it most intrusive. So what we're trying to do is actually look at the actual words and how it affects the concept. And I think they were surprised too, as we were in that engaging conversation, that what the words mean and how it affects the ordinance. The current ordinance states, as presented, that the 24-hour access key holder will be the legal representative of the owner. This, in most cases, is really two different people. You should not designate the person that has 24-hour emergency access, because that could be a simple maintenance person. They might not be the legal person or representative, as that might be the owner himself or the attorney. What we're really talking about is three different entities: the owner, a person to permit access to the building for inspections, which could be a tenant or an owner, and then third, we're talking about emergency key holder access. So if the police chief has a burglar alarm going off in the middle of the night, if the fire chief has fire issues or a broken water head, this 24-hour access person is available to city staff for emergency responses 24 hours. And that should not be binding as the legal representative. A legal representative, actually, we feel, should not be used in the ordinance at all, because that could change from time to time, or possibly the building owner or his lawyer. There's no need to really expand registration information either, as the county treasurer already has taxpayer name for each property, Secretary of State has name of registered agent. And so when you start talking and digging into these and have this discussion back and forth, you can learn a lot from one another. But we would be opposed to having to designate a legal representative at all, but really identify those people that you really need. Again, more work needs to be done in clarification in the area of registration. We have said annual registration is not needed every year. It's just simply busy work for city, but simply a verification process. And I think the city staff that we met with agreed that really only changes to the registration information need to be updated. We don't need to annually register every year, but just a simple verification where the fire chief sends out an email to the person or mails it out, yes, this is correct, and sends it back. You don't need to re-register, but a simple verification process. Twice in the ordinance, it states the city could revoke a tenant or owner's business license for an owner declining a walk-through inspection in another part of the building that maybe the owner has a safe for valuables or an area for privacy. This really allows the city unfair leverage against an owner or tenants to revoke a license, taking away one's right to do a business when one is declining a right when no violation even exists is just totally unfair and not practical. If the city decides someday, and I always look 10, 20, 30, 40 years out, if the city required all businesses to be licensed someday, this could be huge, that the city could revoke somebody's license because an owner in a building and maybe another tenant in another portion of the building could leverage that. So there should be nothing about declining or revoking a license for simply an owner to decline inspection of part of a business or building. I have only briefly touched on the changes. It was a packed hour, I would say the least, very intense in our discussions, and we continue to make this ordinance better. And in this meeting, I think Ellen and the chief agreed with suggestions of our words and added some of their own as Dean was feverishly taking notes. I still think we have many more details to work out, and we're making progress in a good way. Like I say, we only got halfway through the ordinance today, and we offered to meet with city staff as soon as possible again so we can keep moving forward progress. When people can sit in a room together and run through real life situations and examples, their consequences, how it plays out, and we can discuss current law and the process. Progress is made and continually being made. I do ask the council to weigh in tonight as we continue to make progress, but I ask you to not adopt first reading tonight, but to discuss the words of the ordinance, if you agree that we're making progress, and your thoughts and additional concerns that we have not heard of yet. I think you will agree we are moving to move in the right direction, and please don't rush to pass this ordinance or first reading tonight. Possibly have a first reading next council meeting after we get these final changes, and hopefully we'll be able to meet with city staff to go through the last half of the ordinance.
Okay.
Thank you.
Will, I'd like to ask just one clarification at the outset. You mentioned that today's meeting was very productive. You mentioned 3 previous requested meetings with city staff. Were those previously requested meetings honored?
I requested in public hearings to have a question-answer session rather than us just getting up here and giving our 3-minute spiel. I think it's much more productive than you can have certain city staff and certain stakeholders address dialogue back and forth, because I can see what happens when you give a red line to one person, and I don't want to nitpick, but then they mischaracterize our red line, and maybe we mischaracterize their red line or their ordinance when you really don't understand the thought behind it.
But have you had previous conversations honored with city staff regarding the ordinance?
I have...
As a representative of Focus?
Of Focus, yes.
You've made 3 requests?
Yes, I think since this whole process started many months ago and was packed, that the requests that we've had have been honored eventually, even though that they've been denied too. But no, we're moving progress, and I appreciate everybody working together.
Thank you.
Ken Anderson, P.O. Box 584, DeKalb, Illinois. I'm the Executive Officer for the DeKalb County Building and Development Association. Good evening, Mayor, City Council, staff, citizens. As a retired lawmaker, I can say that the changes proposed by city staff today show that this draft is not ready for first reading tonight. It should be ready next Monday, which will give us a week before your next city council meeting, so we can put some modest time into the ordinance that was just released to us 5 hours ago, because that's when the meeting ended. Besides, the Wurlitzer and the Portano properties are being addressed effectively under the existing laws, so there's no good reason to rush to a first reading on an incomplete draft. So I would urge the council to please consider that you do not have the first reading tonight, and continue to take more information from the focus group and other stakeholders on this very important issue here at the City of DeKalb. Thank you.
Thank you, Ken. James Mason.
Good evening, Mr. Mayor, Councilman, staff, and everybody here. What happened today is something that I've been looking for years. The principal parties came together and wordsmithed this document to the betterment of everybody in the community. And I think we have a lot to look forward to in the future if the stakeholders and the citizens and the city government will adopt this type of format. And Anne Marie and the city attorney and the chief, both chiefs, have been absolutely wonderful that we've come this far and they've worked with us. And I say the same thing the other gentleman did. If we can give us another hour or two to go through the rest of this document, I think.
Ted, help me pronounce the last name. Heisey? Thank you.
Hi, I'm Ted Heisey. I live at 43W212 Tall Pines Road, Elgin, Illinois. And good evening, Mayor and Council and staff. I've got two buildings over kind of near the airport on Peace and Pleasant Enterprise, and they're all multi-tenant buildings. And I do have some concerns. I've got multi-tenants, and I've got Knox boxes on the back. I don't necessarily always have access to some of my tenant spaces. I have one tenant that specifically has food product in there. I don't have keys to get into the building. The fire department would have access into that building with the Knox boxes that were required of me. I believe you probably should have some information on who the tenant is in the buildings. They're usually the ones that are there. Frequently, the tenant is the person that may have something in the building that I'm not actually able to or be responsible for, whether it's a forklift with an extra propane tank, a fuel tank that they happen to leave in on a particular day. There are things that I cannot legally go in and just remove his property from the tenant space, even if the fire department comes in and asks me to remove the problem. I've got a couple buildings in South Elgin and one up in Huntley, and the way the fire department works up there, they come in, they inspect it when the tenant's there. I get a note from the fire department emailed to me and to the tenant, and then basically the tenant and I kind of just check off who is responsible, and then we take care of it from there. And it's never been a big issue up on those situations. So I think the Knox box, I don't know if you require that of other people. Our buildings are more like 10 or 12 years old, so I assume some of the 30 and 40-year-old buildings are not, have those on their properties. But I do think that the tenant does have some responsibility, and it should not be strictly the landlord that is looked to for everything. And I do have a question as far as with the multi-tenant, are you going to inspect all 5 units of mine? And if one person has a single violation, are you going to come back a year later or 3 years later? And are you going to inspect everybody? Is the whole building looked at as one item? Or are you going to look at it as tenant spaces if it's totally delineated? So that's kind of a problem I have. And I always have some issues. We came out here, we did a small subdivision, about 10 industrial lots, and we built 2 buildings. And the ordinance here talks about dispute regarding the codes. 10 years ago, I had a dispute regarding codes on how the fire department was looking at the codes on building a new building. I have 2 lots still out here. I left 10 years ago. I went to Huntley and bought 3 acres and put up a 11-unit building up there because the fire department had enacted, this was Dennis Vota, and I cannot think of the fire chief at the time, and they wanted to use a Iowa method of a non-sprinkled volume of water on my property on a sprinkled building. And I spent about $10,000 in legal fees and got to a point of we had to leave the area, and we went up someplace else and built a building, and I still have my lots out here, and I've been a good citizen and a good landlord, and I just don't want this to become burdensome. Thank you.
Thank you. Are there any other in the public hearing on this topic?